Thank you. As you guys are aware, we start in the second part of our webinar, and this part is mostly about practical terms of submission, how to address certain issues, and basically PR submission is a core interest for clients when they approach you. They're not as much interested in obtaining a certificate by itself, and some of them interested to come here as soon as possible on a work permit. But obviously, permanent residency submission is the core interest. So that's why I dedicated certain time to procedural matters. And obviously, you have to understand that permanent residency application was a priority for the government. Like I said earlier, we basically the prime example of doing and following government timelines. We got it in less than 2 months a few times, and it was very significant achievement before COVID. After COVID, we obviously observed some delays. The current time, it's about 12, 15 months, depends on the country of origin or multiple countries of residence, because obviously the government has to go through background check and criminality verification, whole 9 yards. So, but in principle, the permanent residence application should normally be finalized within 6 months, and it's quite possible, to be honest, because of the interest of the government in facilitating innovation and attracting entrepreneurs. Because in a real world, if an investor is waiting for more than a few months, he or she is losing their interest in participating in the project, because obviously they want to move on, they want to commercialize, and maybe some other idea is coming along, and they just losing your that attractiveness, and out of sight, out of love. That's what people say, right? So if of course, like I mentioned about work permit application, and let's continue on that note. If PR application is in process and not finalized, it's okay to file for extension of work permit, even when your commitment certificate is expired, because you already have one and it's just a formal extension. So after that, the officer will assess on a case-by-case basis and will grant an extension. We never had problem with that. The problem usually exists with people not attending, not in Canada, and trying to extend it by filing from overseas. The first question the officer reasonably should ask, and according to manual, why you didn't utilize the first one and now you're asking for the second one and you're still overseas. So just apply common sense and practical knowledge. Like I said, two things you have to apply. Some things are obvious, but some are not, and people ask me, so I try to address certain issues right in this webinar on this page. Each applicant must have separate PR application with personalized business role and scope of duties and filing prepared and submitted separately. They're all covered by the same umbrella, what we call umbrella of commitment certificate, because all names are listed, as I presented an example before. All names are there, each getting certificate, each cross-reference with the project, and if company incorporated, and it should be incorporated, and then they related to that company and they co-owners, they participate on certain positions, but each application goes separate. Why it's important? Because sometimes life goes on not the way that you predicted, and some clients slow than others. And I always joke about it, and let me refresh your attitude a little bit. Somewhere in the Middle East, because I travel extensively, I pick up this proverb about the caravan. People know me for proverbs and jokes, about practical jokes, I would say. So the speed of the caravan is always measured by the last camel. So what I tell my clients, never be the last camel, because people probably will poke on you, kick you, and try to force you, and people feel like you delaying their procedure, because until the last application submitted, Rarely officer will actually assess the whole package because it's probably the same officer who will assess all of the files related to the same project because they want to see correlation. They don't want to see discrepancy between files. They want to see like inline submissions. But at the same time, don't forget, each applicant is a separate applicant for the purpose of PR application. That means each application, when it's ready, better be submitted. Another reason for that is practical. It's not that rare that government change forms. Who practice, you know. And what happened? By the time you prepare the last package, the first can be, fairly speaking, outdated. It's a crime to send the old package because it will be rejected. And guess what? And that happened. Clients came and said, my lawyer delayed and sent it the last moment. And the government got it. And 3 months later, we just realized we sent all forms, but now we cannot resubmit because my certificate expired. And I say, well, that's true. That's correct. You have to apply for another certificate. You have to go through another certification. You have to go through another process, maybe even with another organization, because that investor may be reluctant to work with you because you have lousy immigration counsel, because the counsel killed the project. So always be good counsel for the good reason. So if application is prepared, I always tell people, if application is prepared, send it in, the full package, because from practical standpoint, the lock-in date is there. Okay, the lock-in date will fix the time, the terms, the age of children. Sometimes people come and saying, I cannot wait for my partner because my child turning 22 in 2 months. I have to apply now, so otherwise I will lose the child from the application. You cannot allow to do that from compassionate standpoint. Okay, so those are conditions I listed here, and let me walk through because this is critical. People have to understand those things. And you practicing, you have to be able to explain it to them what government means by that. Those are requirements. When the certificate issued, each applicant holds 10%, at least 10% or more of voting rights attached to all shares of the corporation. If a corporation is already incorporated, that's perfect, that's ideal. If not, that has to be arrangement perfectly described and legally fixed that the person is entitled to 10% or more of voting rights. You better consult with corporate lawyer or apply your practical knowledge and advise clients accordingly. And remember, not or, but and applicants and designated organization jointly hold more than 50% of the total voting rights attached to all shares of the corporation outstanding at the time. What it means, if you have 4 members and you have an investor and you assign 5% to investor and 10% to each member, you all 5 people share 45% of the company. Bad judgment. Doesn't matter how you approach it, bad judgment, because you have to apply practical knowledge and common sense. Of course, you have to pass a threshold of 50% in control shares. And people sometimes coming to me and saying, oh, I have an investor who demands 60%. We want to take him in because he provides a lot of capital, but he is not interested in immigrating. Can we do that? No, you cannot. You have to make another arrangement how to attract capital. But with designated organization, designated investor, applicants must share more than 50% of total voting rights. And the best way of doing that is to incorporate before you actually issue. It's a little secret. People do differently. I share how we do this. The setup of corporation, if it's done properly, gives reassurance to designated organizations, lay everything as it is for immigration. That's why our files process faster, because we have everything in place by the time we file for permanent residency. At the time of receiving PR, that's another matter. Applicants provide active ongoing management of this business from within Canada. An essential part of the operation of the business happens in Canada. People come to me all the time with rejections of other situations and lawyers and consultants and whatnot, and saying, what went wrong? And it's not rare when I see the whole business is in Asia or in Africa or in Latin America, because we work all over. People come and saying, oh, you helped this company, please assess what went wrong in my situation. And I see, well, no operation in Canada. And you're not helping Canadian operation whatsoever. Yes, you do something, you involve in management, but the whole business operation happens outside of Canada. That's not right. An officer has a right to reject. The business is incorporated in Canada. Remember, not all, but and the business must be incorporated in Canada. If it's not incorporated and some lousy consultant told you, I mean, I'm addressing clients now, but let's say you talking to your clients, the business must be incorporated in Canada by the time you get in your PR, Mr. Applicant, because there is no other way to go around the law, and that's requirement. And people say, yeah, we will do it later. No. How about no? Because that's a rule. So this is basic principles of PR submission. If you have more questions, please ask during question and answer series. We will continue.